I'm Michelle Kennedy. I'm an attorney in Cooperstown. The purpose of my presentation is to give you, at least from a starting point, a how-to. How do you begin to take these steps within your town? In order to do that, I think that it's important that you have the foundation as to what statutory authority and case law authority are you relying upon. This is not exhaustive in terms of the authority upon which you rely, but it's a beginning. And so in these next 20 minutes, those are the purposes, and hopefully as we proceed, the information will be clear to you. If not, there will be, from what I understand, an opportunity for questions at the end. The first discussion that you need to have within your municipality amongst the board are weighing both the risks and benefits of the applicability of your land use laws to natural gas operations. In terms of risks, I always make it clear to the municipality that, yes, this is an unsettled area of law. Helen touched upon the statutory under Environmental Conservation Law, Article 23, Title 3, the interpretation of that statute, and we'll go to that in just a minute. But there is not a vast body of case law under that statute. And so we are entering, to some degree, uncharted waters. And I always try to impress that message upon municipalities so that they do understand the potential risks. And mainly those risks are associated with the potential cost of litigation. Since this is an unsettled area of law, there is, in all likelihood, going to be a challenge. How many challenges there are, I think, is to some degree has been overblown. In all likelihood, the first few cases that progress through the courts will begin to set case precedent. And so, therefore, there will not be under this theory of the application of land use laws to natural gas operations, in all likelihood, there will not be multiple challenges. So to some degree, the information, even as a part of this seminar that you're obtaining, and that town council or special council gather, all of that information creates, in some ways, efficiencies and a new body of case law to a certain degree. So this is a nice combination of efforts that we're seeing. And I think it will diminish some of the possible costs of litigation. Benefits, leverage. And this is, in my opinion, the primary reason for taking this step. Without any land use laws, and there are a number of towns, as we know, right here in Otsego County, that do not have any land use laws in effect. Without land use laws in effect, you do not have any leverage. I recently saw an article come across the Sustainable Otsego listserv, and within the article, there was mention of a case in Pennsylvania in which one of the gas companies was suing the town, and we always look at this and think of the imbalance of power. It indicated that the particular town had tried to set setback requirements. This is not something that I would suggest that your town do, because there is an overlap when you set setback requirements with what has been indicated that the DEC will do through the regulations in the supplemental draft environmental impact statement. So not an approach you want to take. However, the town council within that article, he suggested that he, to some degree, was in negotiations with the attorney for the natural gas operation, and he's suggested that the threat was not as great as it seemed. And the reason being, I think it would be apparent to all of us, but he has negotiating power at this point. The gas company also has to spend money on their own attorney's fees. In all likelihood, their attorneys are billing at the rate of $250 or more per hour, and they never stand alone. They always come with the partners and the associates. And so that hourly rate begins to increase a number of times over. With having your land use laws in place, you give yourself negotiating power. And you will need negotiating power because these companies, unlike many of the businesses that we're accustomed to in upstate New York, they do not necessarily have a long-term interest in remaining here, in developing a client base here. The production, we've been told through experts in this field, diminishes over time. And so these are short-term operations. They are not necessarily vested in the long-term interests of your community. So you need negotiating power, because their interest in maintaining some client base will not be what gives them a vested interest in doing right by your town. Number two, your land use laws, in all likelihood, will also create a deterrent to some degree. Again, there are costs associated with litigation on both sides. If the natural gas company has to pay their attorneys at the rate of $250 per hour to challenge your laws, it may be in their best interest to simply appease you. So that creates a deterrent. It also, if the objective of your town is to outright prohibit this industry from operating there, having a land use law in effect that has been properly enacted may act as a deterrent. Number 3, customization. You have the ability, you know your land within your town probably better than the DEC does, someone in Albany. So you have the ability to customize laws that meet your town's needs. You do have to be careful, as I suggested with the comment about setbacks, that you are not overlapping with DEC regulations. Number 4, cost savings, your benefit. Cost savings, I look at this concept very broadly, and I look at it over a great period of time. You have to think of the cost savings that come as a result of preventing incompatibility with competing interests. Many of the businesses, for instance, here in Otsego County, the businesses that surround Otsego Lake are not compatible with this type of industry. Here we have many businesses that are devoted to tourism, that are devoted to food production. These businesses have expressed through different surveys and through public statements that they could become insolvent as a result of this incompatible use occurring within direct proximity. So that's one cost saving. The cost savings to your community and your tax base as a result, again, of incompatibility when you have residential operations that are situated immediately adjacent to industrial operations. One of the companies that's operating here, they engaged in seismic testing in a residential neighborhood in the Middlefield community. All of those homeowners felt that their property value at that particular time, with the possibility that drilling could occur within the residential area, would be rendered valueless. So those are the types of cost savings that I'm talking about. Also, the long-term environmental impacts that you have to think about. The DEC regs are set up such that you have to prove that your community incurred damages. And I will almost guarantee that you will not only have to prove that damages were incurred, but by whom. And creating that nexus is not an inexpensive process. The DEC regs also suggest that you will have to show that you had to expend resources in order to cure those damages. That means money out of pocket first before you're reimbursed. So things to consider in terms of weighing the risks and benefits. Next slide. The statutes, as I said, I'm giving you the information in terms of most immediately what is the statutory and case law authority upon which you're relying. There are 2 provisions underneath the environmental conservation law. The first that we're looking at it's the verbiage that Helen had spoken of previously, which is under Title 23, that local laws relating to the regulation of the oil, gas, and solution mining industries would be superseded by the state's regulatory scheme. The second, for comparison purposes, deals with this analogous provision also underneath the Environmental Conservation Law, Title 27, and very similar provision that the state's regulatory program would supersede all other state and local laws relating to the extractive mining industry. Title 27, also known as the Mineland Reclamation Law, or MLRL for short, it covers the mining of solids. Title 23, on the other hand, regulates oil, gas, solution mining, okay? But as you can see from this slide, the verbiage is almost identical. And the courts, as I began to say, under Title 23, there is only one case that interprets the meaning of that phrase relating to the regulation of the oil, gas, and solution mining industry. It's a lower court case that we'll talk about out of Erie County Supreme Court. Would not be binding on, for instance, the Otsego County Supreme Court. Title 27, on the other hand, has a vast body of case law and cases, as Helen suggested, that reach the New York State Court of Appeals, which is the highest court in New York State. And so we looked, because of the very similar provisions and almost identical verbiage, we looked to those cases under the Mineland Reclamation Law, Title 27, to give us some indication as attorneys as to how this similar provision under Title 23 will be interpreted in the event of a challenge. The first case, and many of you have heard these cases at this point, so I will move through them rather quickly, but Frew Run Gravel Products versus Town of Carroll was decided by the Court of Appeals in 1987. The Town of Carroll at that time determined that mining should no longer be a permitted use within the AR2 district. If there were existing mining operations, those mining operations would become non-conforming uses. The Town of Carroll was challenged by Frew Run Gravel Products, and the court said that this type of decision as to whether or not something is a permitted or non-permitted use within a certain district is a law of general applicability. It only has an incidental impact upon the industry, and therefore the town won before the Court of Appeals. The decision was upheld to not allow this type of extractive mining industry within a certain district. And the court made the connection, of course, that the statute Title 27 and the language relating to the extractive mining industry did not supersede this type of local land use law. So that's the first case that we see under Title 27 going to the Court of Appeals and acts as our seminal case in this context that we're now dealing with. There are amendments. In 1991, Title 27 was clarified to, in effect, codify the decision in Frew Run. And the court and the legislator made it clear at that time that local zoning laws of general applicability, were not superseded by the statute. There is a similar amendment pending before the New York State Assembly and Senate to accomplish the same purpose, so that there would be clarification for the towns. It does not mean that because such amendment has not been passed that you do not have this authority. It simply means that the area of law is unsettled, just as it was when the Frew Run case came before the Court of Appeals in 1987. Next slide. The following case, Gernatt Asphalt versus Town of Sardinia. In this case, the Town of Sardinia determined that mining should no longer be a permitted use within any district. And again, they were challenged. The Court of Appeals upheld their decision to not allow mining as a permitted use within their town. Again, the existing operations would become non-conforming uses. The Court of Appeals could have easily pointed to the amended language under Title 27, but rather the court went through the same analysis that it did in Frew Run and suggested that these are laws of general applicability. They only have an incidental impact upon the industry, and therefore they are not superseded. Envirogas versus Kiantone. This is the case that I suggested came out of the Erie County Supreme Court. It's the only court case that we have with the interpretation of the language under Title 23, but it is very limited in scope. The case indicates that a town cannot require commercial drillers to post bonds. And this decision is not surprising. Number one, there is a bonding requirement underneath the DEC regs, and so this would be another overlap. And it is not a law of general applicability, of course. I'm next going to speak, as I said, this is to some degree a how-to. And I think some of the best examples for you are those that come from the process that is occurring in other towns. All of the information that I will give you with respect to these towns is already public information. This is information that has been discussed at the town board meetings, but of course we can't all be everywhere all the time. So I think it's helpful, as I said, this is your network. These are the efficiencies that you have to create. You have to call town supervisors in other towns, ask how the process is going there, tap in on their resources. And so I'm giving you the models of what is occurring around the lake. This is not a finished product. There has not been a vote to pass in any one of these towns, but I think by looking at some of the different approaches, based on their different circumstances, it will give you a roadmap to a certain degree. And I also do want to acknowledge the public officials in these towns, just generally, for the extraordinary efforts that they are making to take these steps. I know that their service has been greatly appreciated by the residents in their towns. And as I said, these are uncharted waters, and the residents there certainly appreciate the steps that they're taking. So I'll first address the town of Otsego. This is the most traditional example. Within the town of Otsego, there are particular districts, and in each of those districts, there are permitted uses. If a use is not permitted by its absence, it is non-permitted. Within the RA2 district in Otsego, there a mineral extraction is allowed. That is the only district within the town of Otsego in which there is a provision for mineral extraction. However, there is language throughout the town of Otsego's zoning law that indicates that never contemplated was this type of gas, oil, or solution mining industry, but rather sediment mining. And so what has become important for the town of Otsego is to make that clarification absolutely clear. Because again, we would have incompatible uses within this particular district if this heavy industrial operation were allowed to occur there. And so on the second part of the slide, you see under the definition for mineral extraction the clarification. Specifically listed are the different types of minerals that may be extracted, and then instead of a general reference to other minerals, it has been clarified to indicate that only unconsolidated minerals would be something additional that could be allowed, and unconsolidated minerals also in their proposal is clearly defined. Again, this is just clarifying language within the town of Otsego's zoning law that, of course, any use, or proposed zoning law, that any use that is not permitted is, is not permitted is prohibited. The Planned Unit Development District. This is a provision within the town of Middlefield's zoning law. It also appears under town law, and it's a mechanism by which towns can create an overlay district so that they have more discretion in terms of what operations are situated where. It gives some flexibility. And so with the inclusion of the Planned Development District, a slightly different approach becomes necessary, and we see this in the town of Middlefield's proposal. The town of Middlefield also has added clarifications to indicate that heavy industry and oil, gas, or solution mining and drilling are explicitly prohibited. And the reason for this explicit prohibition, again, is because the Planned Development District does create some flexibility, but with that, at times, can also become some ambiguity. And the Planned Development District within Middlefield has criteria for approval such that this type of operation should never be permitted as a planned development district. But in order to avoid any wasting of resources, the town is moving forward with this type of clarification within their zoning law. As I said, none of these provisions have passed at this time, but they're just different models that your own towns can look to. Town of Springfield. The town of Springfield has a comprehensive plan, but not a zoning law in place. So the town of Springfield with the exercise of its police powers under municipal home rule, is in the process of drafting a local law to prohibit heavy industry within the town. This is another approach that your town could consider. However, you may want to eventually, again, I think this issue that natural gas operations operating within our county it indicates that to some degree times are changing, and our towns, they may be best protected by moving towards land use laws. And so eventually, if your town were to follow this model, they may want to look towards a more comprehensive land use law over time. But this is certainly a measure that you can look to implement under municipal home rule law. Moratoriums. I've been asked a number of questions about moratoriums. I generally have discouraged the use of a moratorium, and in particular, any moratorium that would be targeted towards the natural gas industry. What I would advise instead, if your town really does need to buy some time, they may want to look to a moratorium on site plan review, on building permits. Those would be broader based, but they would still allow you potentially some time to develop a comprehensive plan and land use laws. So I would just say tread carefully with moratoriums, but if your town has no other form of regulation, again, a moratorium on site plan review or building permits or some other permitting that your town may have might be a method that you could look to. Amendment versus enforcement. I know that for a number of town officials, again, you are fiduciaries to your town, and in such capacity, you are there to preserve the assets of the town. And how those assets are defined, they can be defined in a number of ways, but of course, your budget and maintaining a certain budget does not always allow for the potential costs of litigation. And as I said, I think I start out with the weighing of this process because the costs of litigation are ever present on your minds. That being said, I think that it's important to keep in mind that there's a difference between amendment or adoption of the law and enforcement. And in all likelihood, the costs are going to come at the time of enforcement, not at the time of amendment or adoption. And so in order to give yourselves some negotiating power, as we discussed, even if you may not be in a position later on to enforce, I view this as a conservative measure so that you are preserving some negotiating power. Not every town will decide that they are in a position to litigate this issue. Hopefully there will be some case precedents as we go along to guide the way. But, you know, as I said, there's a balancing act here. You have to look at amendment versus enforcement phase. Your battle's probably not going to come at the time of amendment. It's more likely to come at the time of enforcement. Timing matters. This is a conservative measure, but as such, you have to implement at the appropriate time, whether you do so initially through a moratorium, a land use law under your municipal home rule powers, or more comprehensively in the form of land use zoning law. Once vested rights are established, you will not be able to stop those operations. If the DEC has issued a permit, if there has been a substantive investment in the project, it will be very difficult to try to interrupt those operations without incurring damages if a preliminary injunction is granted and then the court decides later that it was not warranted. So this is something that you want to act on upfront, if at all possible. It also becomes more difficult to argue that the use is incompatible once you have compressor stations situated in your town, wastewater treatment facilities. It becomes much more difficult to say this is a residential agricultural area when you already have these types of industrial uses situated there. You might consider, if you're in a situation where you do have some vertical wells in the community, a no conversion clause indicating that those wells cannot be transferred from a conventional type well to a high volume hydraulically fractured well. You might also consider a sunset provision. If a well has not been used over a certain period of time, that it could ultimately be phased out through your land use law. In my opinion, this is the part where you will have to rely most heavily upon town council, special counsel, planners, land use attorneys, etc. It is the procedural part of this process. I showed you some of the cases, Frew, Gernatt, in some ways to give you that sense of confidence that this is not, it's not a science, it's not a mystery, how do we do this? There are certain permitted uses and there are non-permitted uses within districts. On the other hand, the procedural aspects are complicated. There are a number of statutes, many of which I have listed here, and Nan gave you some of the benchmarks, but within each of those statutes are finer details as to how you go about implementing these laws, and so you have to pay careful attention to the procedure, consult with experts on the subject. There is a much higher likelihood that this type of land use law would be set aside as a result of some flaw in procedure than the actual substantive provision. So just tread carefully when it comes to procedure. That's all. Thank you. Thank you very much.